We good.
This is case number 18-154-583. This is Macomb Community College versus Aramis Hall. That is before the court of a petition for issuance of a subpoena. In fact, a subpoena was issued and set for a hearing on today's date. Your appearance for Macomb Community. All right, do I have Aramis Hall on the Zoom? All right, the court will come back to that matter. Court now calls case number 20-146-005. This is Progressive Marathon Insurance versus Kelsey Salter. And that is before the court on a motion to set aside default and then the alternative motion for relief from judgment. The record should reflect in this matter that a judgment was entered by default on the 19th of February 2021, looks like. And that judgment is for $13,057.52. Your appearance for Progressive Marathon, please.
Good morning, Your Honor. Jennifer Dillo appearing on behalf of the plaintiff, P69855.
All right, thank you, counsel. Good morning to you. For defendant Kelsey Salter, your appearance, counsel.
Good morning, Your Honor. Alexandria Taylor appearing on behalf of the defendant, Kelsey Salter. My P number is P75271, and Ms. Salter is also on the Zoom.
Thank you. Good morning to you, Ms. Taylor, Ms. Salter as well. All right. This is your motion to set aside the default judgment that was entered as the court previously indicated. I do see that in September of 22nd, there was a notice of judgment lien that was filed at that time as well. Just looking back at my file, and I note the judgment entry date of February the 19th, 2021. All right. Have the two of you, Madam Counsels, had an opportunity to talk about this matter at all?
I have not spoken with Attorney Dillo. I did initially have a conversation via email with, I believe it was Attorney Best or one of the attorneys that was on this that I have reached out to. We had kind of an email chain trying to resolve it. We were unable to come up with a resolution. We were kind of far apart. And so.
All right, thank you, counsel. You may proceed at this time, Ms. Taylor.
Your Honor, as I stated in the motion, in December of 2021, my client received a notice from the Secretary of State that her driver's license was suspended due to a civil judgment. She reached out to my office because we had recently resolved another matter, and I looked it up, and that's how we were informed of this. When I did reach out to plaintiff's counsel, I asked them to send me the complaint, the default, the proof of service. I sent the green card, the copy of that to my client. She was unaware of whose signature it was. It was not her signature that was on that card, and she just had no notice of this. The fact that her driver's license has been suspended has been just a severe detriment to her. My client is not aware of the facts surrounding this incident when I forwarded the complaint and the pleadings to her. But even if the court was to find that this is a valid judgment, at the end of the day, my client would need to be able to make some sort of payment plan and to have her driver's license reinstated, because this is almost akin to like a debtor's court. Like if she doesn't have a valid driver's license, she's a single mom, like she's unable to work. And so it's kind of counterintuitive, because how could she even pay anything if she doesn't have a valid driver's license to get to and from her employment? And so, Your Honor, we would like the default set aside to be able to look into this more to see what is this like I said, my client does not even know what this underlying case is even about. But even in the alternative, if the court finds this valid, she would need to be on some sort of payment plan in order to get her driver's license reinstated. And we did our due diligence, reaching out to counsel. I mean, for a few months, we were trying to resolve this, but the parties were simply too far apart. And what plaintiff was requesting the amount for Miss Salter to put down, like she simply was unable to do that. As the court stated, there was a notice of a judgment lien. My client informed me this morning that there was some sort of lien placed on her vehicle, which, that she doesn't really have an issue with that. I mean, the biggest thing here is the fact that she is unable to obtain a valid driver's license because of this. And that's it, Your Honor. Thank you.
Thank you, Counsel. Before we go to Ms. Dillo on that, we'll hear from Ms. Dillo. Obviously, where there is a judgment arising out of ownership of motor vehicle, things along that line, the state law, whether we like it or not, allows someone holding a judgment under those circumstances to, in fact, lean upon the license in such a way that it would be suspended and the defendant would not be able to operate a motor vehicle. That would undoubtedly work a hardship. And I think one of the objectives is to try and get the judgment satisfied, and that's why some entities will take that approach. It is permitted by state law in certain circumstances. As to the propriety of setting aside the judgment, Ms. Dillo, counsel indicates that the reason is rooted in a lack of notice, and indicates that her client has informed her that any signing on any document is inconsistent with her signature. I note that in the court's file, that is the basis for which service was had. I see that a proof of service was filed with the court indicating that service was taken by registered or certified mail. You may proceed at this time, Madam Counsel.
Thank you, Your Honor. In regard to the good cause, I have to rely on the proof of service. The certified mail was sent restricted. It is stamped. It is signed. And I understand the defendant's arguing she did not receive notice. The judgment appears to have been mailed to the defendant as well in February. And I know that there's been some prior discussions with counsel in my office. But even putting aside good cause, the defendant needs to also show the requirement is both good cause and meritorious defense. And in support of the meritorious defense, the defendant not provided an affidavit of facts. There is an affidavit from defense counsel, but it does not provide any facts that support the meritorious defense. I would note that the police report attached to the complaint indicates the defendant was cited for disregarding a traffic signal. The police report indicates the defendant acknowledged at the time of the accident to running, I believe it was a red light, or disregarding a stop sign or a light. But there's also a witness report as indicated on the report. And there was no insurance on the vehicle driving at the time of the accident. Basis of plaintiff's complaint. I would argue that the defendant has not set forth a meritorious defense, which is required to set aside the default judgment. So we'd ask the motion be denied.
Right. Before we go further on this issue, the second prong of the typical motion to set aside default does not become really activated or required where the motion is rooted in a lack of service. Where there's a claim of a lack of service, then
I got a video right now. I have it for the board. I told me I got
the person that's talking with the phone number beginning in 370-704-4729. I put you on mute again. You come back in talking while I'm conducting the hearing, and I'm going to dismiss you from the hearing. You do have to stay on mute until your case is called. Thank you. So in this case, Madam Counsel, Ms. Taylor has brought a motion pursuant to a claim that there was a lack of service, that her client did not receive service. So the second prong is not invoked to the extent that there was no service provided or notice provided under the court. That's kind of the challenge here. Otherwise, the court would then have to make the second inquiry as to whether or not there is a meritorious defense. And the only thing that's been offered by way of any claim of meritorious defense is that counsel on behalf of her client indicates that her client is not aware of the circumstances underlying this case. So, Ms. Taylor, anything further in this regard?
Nothing further, Your Honor. Thank you.
All right. So, when I take a look at everything as it relates to the showing of good cause in this matter, and the claim of good cause is written, and they claim that a signature on a green card does not match the defendant's signature in this matter. There's really not a underlying valid defense that has really been raised in this matter. It does look like that may not in fact be enough. However, where there's a claim that the signature doesn't match, that someone else may have signed off with a document, typically what happens under those circumstances is that there's something in the nature of an evidentiary hearing where the card is brought in, the person that filed the proof of service with the court is brought in, and then testimony is taken in that regard. If it seems in this matter that the underlying issues here, that is that there was an accident, that there's a police report underlying that accident, and so on and so forth, then going through some of the issues regarding service might be an act of futility. So I don't know that that is the best approach to take. I am inclined under these the circumstances of this case to allow for the setting aside of the lien on the driver's license, but I need the attorneys to talk on this and see if we can find a way forward to try and get this in some type of payment plan, some type of understanding as to the dollar amount, and then go forward from there. Counsel has convinced me that the license suspension works as substantial hardship, and that the defendant is not really unwilling to proceed by way of trying to work out something to address the judgment while being able to go on with life in terms of going to work and things like that. So let me have the two of you talk in the breakout room. It's not a forced talk, but I think you see where the case is at this point. And let's see if we can find some traction going forward. And then just come back in and I'll prioritize your matter to try and get you moving forward. So
Thank you, Your
Ms.
Honor.
Daly, a notification for breakout room number 1.
Yes, I have that. I'll go now.
Ms. Dillow, I'm also sending the same to you. Just one moment here. And Ms. Salter, say something to me so I can send you to that breakout as well. Ms. Salter?
Yes, I'm sorry. I didn't know you were talking to me.
No, that's okay. I just called out for you. I'm sending you to that breakout room as well, so that you will be
Okay.
able to talk about this matter. There is your notification, ma'am.
Okay.
All right, the court calls case number 21-164-857. This is JHPD Finance 1 LLC versus Michelle Harrison. The matter is before the court on an application for entry of default judgment. I also have it noted as a date for review. Your appearance at this time for plaintiff.
Yes, good morning. This is Natasha Dixon on behalf of JHPD Finance 1 LLC. My PIN number is 82333.
All right, thank you, and good morning to you, counsel. Do I have defendant Michelle Harrison or somebody representing Ms. Harrison present at this time? Ms. Harrison?
Good morning. I'm sorry. Yes, this is Ms. Harrison.
Not a problem. Good morning to you, Ms. Harrison. Ms. Diddix, update me, Madam Counsel, on what's going on here.
Yes, Your Honor. I did speak to Ms. Harrison recently. Our client did finalize basically the settlement terms that I could offer. So I did call Ms. Harrison on April 14th. And just to explain what she would be receiving in the mail as far as the settlement documents. And those were mailed to her on the 15th. So hopefully she has received them by now, and got a chance to review the documents.
All right, is that the case, Ms. Harrison? You had a chance to review the settlement documents, ma'am?
I have not had ample time to review. I did receive the document yesterday.
Okay, and so I guess my question comes centered around whether or not the terms are straightforward. there's an agreement regarding some amount and those kinds of things. Is that correct, Ms. Harris?
That is correct, yes.
All right, so the question, I don't want I don't want to delay this case and be setting other hearings and stuff. If you're likely to enter into the agreement that has been submitted to you, then I need to know that. If not, then the case goes in a different direction.
No, I am likely to agree to the terms. Because of course I'm not an attorney. I just wanted to make sure I understood the legal terms. So I just wanted to have time to review before, of course, I put my signature to that document.
All right. So are there any questions that you have for me regarding the document?
No, not exactly. Not exactly. No.
All right. All right. So how much time do you think you need to finish your review of the document?
Just a day would be fine. It's not long at all.
All right. All right. Very well. So I will set a control date on this matter 1 week from now. I will anticipate that I will receive a copy of the agreement back to the court, and I'll take a review to make sure that that's been done approximately a week from now. That specific date is going to be
28.
The 28th. That is for 28, 22. And that's going to be at 9:45 a.m. 4/28/22 at 9:45 a.m. If the agreement has not been signed, parties have not reached an agreement, then the court will address the matter at that time. If so, I'll just need to be informed that that has in fact been done, so we can get the order to the court and get it signed and sent back out to the parties. So 4/28/22, 9:45 a.m. Matter set for review at that time. Thank you. Good day to both of you.
Thank you.
Thank you, Your Honor.
The court now calls case number 21-66458. This is Biomolecular Integrations versus Auto Owners Insurance Company. The matter is before the court. Looks like set on for a motion hearing. Counsel, your appearance for the plaintiff in this matter.
Good morning, Your Honor. Richard Brewer, P31124 on behalf of plaintiff.
All right, thank you, Mr. Brewer. Good morning to you, sir. For defendant auto owners, your appearance at this time, please.
Good morning, Judge Nancy Goodell on behalf of auto owners.
Your P number, if you will, Ms. Goodell, please.
P84746.
All right, thank you. Good morning to you as well, ma'am. So I know that this has been up in front of me a couple of times. So somebody update me on where we are regarding this matter.
Judge, we were before the court once before on this, at which time I advised the court that I hadn't had notice. I had just taken the file over and didn't have notice of the motion. The court allowed me a period of time to respond. I've responded, and so we're here for a decision.
I'm sorry, Judge, we didn't receive a response.
I do have plaintiff's response to this position, and my timestamp is April the 5th. And so you haven't received it yet, Madam Counsel?
I have not.
So I'm sure you want to take an opportunity to get a look at that. So can I get you guys back here next week? And counsel you, I don't know what happened, but maybe get the document over to Ms. Goodall.
I'll make sure it gets over today, Judge. I thought it had been served.
Just give me 1 second, Judge.
Sure.
I don't see one in my file. I'm gonna check the fact before I.
I know that this matter addresses issues of standing and release, whether or not the underlying claimant in this matter could have released the claims that may be brought, may now be brought by Biomolecular. So I'll drill down on those issues, but I certainly want to make sure that the parties respectively have the other parties' documents before making
I mean, Judge, I think it really boils down to the fact that the claimant in this matter, signed an assignment for past, present, and future medical expenses. He was represented by the same exact plaintiff's counsel. I mean, that plaintiff's counsel also knew the terms of that settlement agreement. Whether or not they represent Mr. Hunter now is irrelevant. They represented Mr. Hunter. They signed a settlement agreement. And that settlement agreement had all medical expenses encompassed to it.
Right.
I mean, there really isn't an issue here. And I mean, I don't want to speak for plaintiff, but last time he said he knew that there was a settlement and it included all these past, present, and future benefits, and that dismissal is really appropriate. So I'm not really sure what the argument could be at this point.
Well, probably that's perhaps that's why you would want a copy of this, the document. It sounds to me that, and I'll allow counsel to speak on this issue. Don't want to waste any time if it's going to be necessary to get a copy of the opposing document. But it sounds like counsel is making the argument that the defendant Hunter, claimant Hunter, was not in a position to waive the rights of biomolecular. And I know that your argument is that how could that be true when he represented the defendant and the resolution was a global resolution affecting all of the assignees, if you will. Mr. Brewer?
Sure, Judge. The bottom line is this: you can't give away, you can't release something that you don't own. And under covenant, if there's an assignment, the injured party doesn't own that claim. And in fact, we never made this bill part of our claim when we were representing Mr. Hunter. That's evidenced by the case eval summary that we submitted, which did not include the biomolecular bill. And we didn't include it because there was an assignment and there was never any revocation of assignment. The Supreme Court told us in covenant that if there's an assignment, that belongs to the party to whom the assignment was given, which in this case was biomolecular. It did not belong to Mr. Hunter. And defense knew, the insurance company knew that because we never claimed the biomolecular bill. So Mr. Hunter released everything that he could release, both past, present, and future, but he couldn't release the biomolecular bill because he didn't own it.
Okay, and you didn't make that known during settlement because, I mean, it has all present, past, present, and future.
Sure. But it's
medical expenses. And
not,
you represented him, so you would have known.
it's not plaintiff's job to carve out bills.
I'm not listening at this point because when two people start talking, you know,
I'm sorry.
I stopped listening. Mr. Brewer, you were making an argument. Ms. Gadala, you began to address that. I'll come back to you, Mr. Brewer. Ms. Gadala, you may now.
Thank you.
Yes, Judge. I mean, I don't know how he could say he didn't know of these bills and they were specifically carved out of an agreement that they agreed to from his firm, having all medical expenses. They encompassed every medical expense. So they wanted to make a specific inclusion for these bills that would have been set in the settlement agreement. I mean, you agreed to something. They knew that that bill was there. It was not, I mean, those bills were there prior to the settlement. So they can't say that they were never encompassed.
Right. So, Mr. Brewer, the fact that the specific claimant is not, that is biomolecular, is not included in the settlement agreement, would not be a dispositive issue on this matter to the extent that they otherwise had notice of this resolution, correct?
Judge, you can't release something that you don't have the power to release. And the Supreme Court unfortunately said that the claimant, Mr. Hunter, didn't have the power to release the biomolecular bill. That bill belonged to biomolecular by virtue of assignment. Defense knew that because we never included nor claimed the biomolecular bill. It's not plaintiff's job if if a release, which is drafted by the defense, wants to carve out a bill, they can carve it out, but that's not our job. We can only release what we own, and we didn't own the biomolecular bill.
Did the biomolecular bill provide any notice of exception before the settlement was completely resolved?
We never claimed it. We never claimed it in the case evaluation summary. We never claimed it at facilitation. We never claimed it because we didn't own it. There are a lot of other bills that we didn't claim either because we didn't own them.
But the settlement did indicate past, present, and future bills. Is that correct?
That's correct. No dispute.
Thank you, sir. Ms. Goodall, you get the last word in the motion.
Yes, Judge. I mean, there's really no issue of material fact here. These were all settled. I mean, I don't get the connotation that he didn't include that bill and it's plaintiffs doesn't have to include every bill and drafted by the settlement agreements drafted by the defense. I mean, that's not the point. The point is those bills were there prior to the settlement agreement. Plaintiff was represented. He was not unrepresented. I think it'd be a very different scenario if plaintiff was unrepresented, but plaintiff was represented. And it's, interestingly enough, it's the same exact firm that's coming to claim the biomolecular bill, saying that they didn't have rights to it. I mean, there is really no dispute. The settlement agreement is what it is. If they wanted a specific exception for assigned bills, that could very well be put in a settlement agreement limited to assigned bills, but that wasn't there. There was nothing there. I don't understand the point of coming back and forth and, I mean, wasting judicial resources at this point. I think it's a very clear-cut issue.
Fine. I certainly don't think under the circumstances that there's a waste of judicial resources at this point. I do think that the issue is pretty clear, and that there is a settlement of the claims regarding this matter, and that biomolecular was not made a part of that settlement, but that does not accept them from the settlement or exempt them from the settlement. It would appear then that where there is a global settlement that is reached by Mr. Hunter, where counsel for biomolecular now involved in this case is a part of that resolution. That resolution addresses past, present, and future medical type issues arising out of the particular claim of accident that was in the case involving Hunter. That would preclude the bringing of the biomolecular integration matter at this time. For that reason, I will grant the motion for summary disposition, finding that there is no genuine issue of material fact and claims have been resolved in the previous matter. That is, of course, determination. The underlying matter, strike that the case would be dismissed on the motion for summary disposition. Madam Counsel, you may submit your order to the court.
Okay,
Thank
Judge,
you,
with
Your Honor.
prejudice or without?
I'm sorry.
With prejudice, Your Honor?
You have the email address, Ms. Goodall?
Oh, yeah, can I get it, please, Judge?
Yeah, that's Latifah, Latifah dot, last name is Hunter at 36, that's 36th at 36districtcourt.org.
Thank you, Judge.
Thank you, Your Honor. Have a good morning.
Thank you, Mr. Brewer. Good day to you, sir.
Judge, one last question. Should I put the order with prejudice? Dismiss with prejudice?
Well, I don't typically sign a with prejudice order. You can put that this resolves the claims before the court.
Okay, perfect. No problem. Thank you, Judge.
All right, we're back on the record in the subject 6005. That's Progressive versus Kelsey Salter. Thank you, counsels. I saw back here, Ms. Dillow, and where is Ms. Taylor? I saw you
Right here,
as well.
Judge.
Welcome back, Ms. Salter. Ms. Taylor, update me regarding this matter, if you will.
Your Honor, so Ms. Dillow and I had a discussion and we made a proposal for monthly payments, and she needs to take back to see if that will be approved. And when we discussed removing the lien from her driving record, we think that it's easier if the court issues an order, that we, it'll be easier for Ms. Salter if the court issues the order to remove it.
All right, I will certainly assign something along those lines. It will be contingent upon any agreement reached by the parties, because the plaintiff, because it's involved in an automobile accident type situation, the plaintiff has the right to advance, something against the defendant's driving privileges.
Yes.
So Counsel, Ms. Taylor, if you want to draft something, I mean, I could get to it, but.
Yes, I'll draft an order, send it to Ms. Dillo for approval. Then once she approves, I can send to the court. What's the best method to send to Your Honor?
And that would be the following, Latifah, LATIFAH .Hunter @36districtcourt.org. And I'm trying to move this. I'm trying to move this, as if you will, on that issue today. So maybe you get something emailed to me today. So the order should simply say that the parties have reached an interim resolution or some type of resolution whereby the parties agree that the order or that the notification suspending defendant's driver's license will be set aside, contingent upon completion of an agreement that the parties have reached, and that's about the extent of the language that should be contained therein. You would have to identify the driver's license number, et cetera, in the full name and driver's license number in the order, so that you could present it to Secretary of State and have it.
Okay, I got it, Your Honor.
Your Honor, just to clarify, when I thought the court was ordering that I'd rather it not indicate that the parties have agreed, because I thought that was what the court indicated it was going to set aside the driver's license suspension. And we were just going to enter that order.
Got you, Ms. Dillon. So Ms. Taylor, the nature of the order would be on motion of defendant and on and the parties having reached a financial agreement for payment on the judgment. The court sets aside the order of suspension, et cetera. You got it?
Yes.
Okay, and make sure you put the full name and driver's license number, date of birth, that kind of thing, so that you're covered when you present it to the Secretary of State. So the design of this is that it is on the onus is on the court setting the suspension aside and not by way of stipulation. But the reasoning for the court doing that is that the parties have reached a way forward on the underlying judgment.
Okay, I got it, Your Honor.
All right. All right. Anything else at this time?
Not from the plaintiff.
All right. My order further indicates that the motion to set aside the default in this matter is denied, and that the motion for relief from judgment is granted as set forth regarding the driver's license.
Okay, got it. Thank you, Your Honor.
Thank you. I await your order. Good day to the two of you.
Thank you. Likewise.
All right, now the court now looks to case number 21-17-0878. This is LVNB funding versus John Mance. The matter is before the court, settling for a scheduling conference. The court has received the defendant's answer to the complaint in this matter. The complaint pleads for damages in the amount of $1,595.53. This is regarding an account formerly Credit One Bank. All right, plaintiff, counsel for LVNB funding, your appearance at this time, please.
It is Craig Fay, P81401.
All right, thank you, counsel. Good morning to you. I'm looking now for Mr. John Mance or counsel for Mr. Mance. Say something if you're here, please.
Here, John Mance, Your Honor.
All right, thank you, Mr. Mance. Good morning to you, sir.
Good morning.
It looks like I'm looking at your answer regarding this matter. You said something to the effect that you never entered into the card agreement. Is that it?
No, what I'm looking at is the information that I received. Like I said, I got this notice. The first thing that I got information from dealing with this matter was the certified mailing from the plaintiff So I'm kind of unsure of actually the amount. The issue is not me owing the amount, it's just I had no knowledge of the amount. And so I was entered into a bankruptcy at the time, signed in it, got into the case, pretty much filed it in 2015. It was confirmed in 2016. This matter here states that I signed up for something in 2017. Over that course of the period of time, I didn't receive any information from the plaintiff dealing with, you know, what I owe, what have you, until I got this certified mailing. Not saying that, hey, this ain't my debt. It's just at the time I was in a bankruptcy, was unable to pay anything. I was getting $1,500 taken from my check every 2 weeks. So funds were very limited, was barely scraping by. My bankruptcy was discharged in 9/8 of 2021. I'm just now getting everything situated, getting back on my feet, coming out of the bank. This is when I got this information about this case on February 1st, 2022. And now I'm just kind of looking at it like, well, if this is my debt, I'll take care of it. I need time to pay or some kind of payment agreement. That's all I'm really asking.
Gotcha, sir. All right, so the bankruptcy that you were talking about, it was a reorganization where you were reorganized with a trustee paying bills over a period of time, and then ultimately you close that out, correct?
Correct. That was, if you want to have the case number, do you need that?
No.
Okay.
No, not necessary for that. Just wanted to know what type of situation it was. Thank you.
Yeah, it was a Chapter 13 bankruptcy. It was discharged on 9/7 or 9/8 of 2021.
Gotcha, sir. It looks like there's not really much of a dispute regarding the claim. So why don't you see if you can get this worked out? Mr. Fay, would you take a moment to talk with Mr. Mance? He's looking for a way forward, perhaps some type of payment plan that will work for him.
Sure.
And get this all wrapped up. So what I'm going to do is I'll send the two of you to a breakout room just to see if you can get to a conclusion on that. And if not, then the court will give some other direction, but it looks like it may be something that you'll be able to talk through and work it out. So I'm sending you both to a breakout room, and once you're done, you can come back in.
Your Honor, I just wanted to, I'm also appearing on a different matter. It's the last three of the case number is 716, and that's from 2015.
Got you, and I will hold that one until you come back on that. What was those last three digits again?
716.
716. Okay, we'll hold on to that one.
Perfect.
And I will return, sir.
All right, thank you.
All right, this is case number 22-177-174. This is Astera Credit Union versus Robert Lee Nolan. The matter is before the court set on for a scheduling conference. The court allows service by alternate means, and looked like service was completed. That was set on for review on today's date. All right, your appearance for Astera Credit Union, please.
Good morning, Your Honor. May it please the court, Stephen Bequicchio on behalf of Astera Credit Union, P number 62076.
Thank you, Mr. Bequicchio, and good morning to you, sir. Let me see if I have Mr. Nolan here, Robert.
Good morning. Yes, good morning.
Good morning to you. What's do I have Mr. Robert Nolan?
Yes.
Yeah. All right. Good morning to the two of you. What's your name, ma'am?
Catherine Noden.
Thank you, Ms. Nolan. Good morning to you as well. All right. So I set this up for review, and as I look at folks, I'm starting to remember something about this case. So update me a little bit, counsel.
Your Honor, thank you. And thank you, Mr. Nouden, and your sister, I know, for appearing. There's not much new to report, Your Honor. We, as you know, received our order of possession at the last hearing. We provided that to a court officer for execution, and in the interim, we were awaiting some information from the plaintiff regarding the potential whereabouts of the car. It's believed that Mr. Nowden's son is driving the car and has the car. And our court officer, I believe, in some of his investigations has confirmed that. The problem is the address. We can't locate where the son is, and are hopeful that the defendant would be helpful in that, in providing us the address and the whereabouts of the vehicle and the address of the son who is driving it. So that our court officer can essentially recover the vehicle, provide it back to the plaintiff to exercise its right of sale and apply it towards the debt.
Right. All right. So you understand what's going on, Mr. Snowden, and I know Ms. Snowden has been working along with you on this matter. You understand?
Yes.
So they're kind of like two tracks on this. One is the effort to get the vehicle so that any offsets that you might have regarding this claim, because the claim is in excess of $13,000. Obviously, any amount that car could be sold for, et cetera, would reduce the amount of claim. So the second part of this is that the case still goes on. There's one element of the case was for claim and delivery. So we're still trying to get that part of this case done. But it looks like the case also involved a claim for breach of contract or breach of agreement. So it looks like this is a case where Mr. Nolan co-signed or something for his son. Is that about the size?
His nephew.
Nephew?
Your Honor, no, that's not the case. Mr. Nowden was there. He did not co-sign. He was the only signatory on the loan.
So essentially, as the only signatory, he purchased it for his nephew, and it looks like that hasn't worked out. All right.
Yes.
So, Counsel, you want to leave more time to try and get the
But he
Your
talked.
Honor, go ahead.
I'll come back to you in just a moment, Ms. Nolan. Come right back to you, Counsel.
Your Honor, I'm afraid that without the assistance of plaintiff as to the potential whereabouts of the son, we're going to just be, grinding our wheels here. On the track of the replevin and the order of possession, obviously it's in the best interest of the defendant here to get us that information. And I would ask that plaintiff provide that today. Obviously, I believe they know where their family lives, so we can at least get that information and move forward on that. As far as the breach of contract, Your Honor, a couple things. I'm not aware of an answer. An affirmative defense is being filed here. That time has passed, and regardless, there are no defenses here. They've admitted to signing here. So I would anticipate filing for a default and default judgment for the entire amount. And then to the extent the vehicle is recovered and sold, then we would apply that towards the judgment amount. But so those are the kind of the two tracks you alluded to, Your Honor, and that's our plan for both of them. I think the second one is a bit easier. If Your Honor is inclined to have us motion this for summary disposition, I think the result will be the same. Not to be presumptuous, but there are no defenses here. And so on that track, I think that's the easier of the two. On the replevin track, again, if we can get an address from Mr. Nowden or Ms. Nowden right now, that would be terrific.
All right, thank you, Counsel. And the language used here regarding replevin is the same thing as recovery of the vehicle. That's what Counsel was talking about. Where the two count complaint basically says claim and delivery, give us the vehicle back so that we can use that to pay some of this debt. It will be beneficial to the defendants. And then the second part is that they're indicating to the court that they're entitled to judgment on the breach of contract because the vehicle hasn't been paid for based upon the agreement. So those are the two things that's going on. Ms. Snowden, I know that that you're not a defendant in this matter, but you've been speaking for Mr. Robert Snowden. Anything you wanted to say, Mr. Snowden? Anything you want to say at this time?
No, he talked to his nephew, and his nephew said he will pay it off if he can get to keep it. And as far as that, I secretary, and she said she was out of town. She couldn't answer none of my questions. And I was trying to see, can he keep it in a dollar amount? So before we come to court, I could have a check or something, but she hung up on me, asked me how I got a personal number. So I couldn't resolve that.
All right. Is there a number that you can give, that you can provide to counsel, to the attorney today, and to your nephew, so that he can make contact with the attorney and try to get this resolved? If he's talking about paying it off, that might resolve the entire case.
You got that boy number?
Oh.
ET.
Oh.
He said he called him, but he didn't keep his number. He don't know how to work his phone no way. So.
All right. Well, now here's what's happening. I mean, you're not helping your cause very much here, because you got a situation where it's starting to lean towards the court having to enter a judgment against you for like $16,000, and all the things that we're talking about is what will
He going for the full amount.
From perhaps getting a judgment entered against you. If you have a nephew that's talking about he can pay this off, then you want to do everything you can to make the connection so that he can get that resolved. Otherwise, the defendant, excuse me, I should say, your nephew is going to end up keeping the car, if you will, and you're going to end up owing $16,000. That's kind of the irony in all of this. All right, so what I'm going to do is I'm going to give you, I will take under advisement the defendant's, plaintiff's oral motion for entry of judgment on the pleadings and/or by default, and I will make a decision on that in the next 30 days when we come back. Hopefully, you can get the attorney in touch with your nephew, and if he wants to pay it off, that resolves it for you and everybody else involved here. So,
Your Honor, can I address that point about the nephew?
yeah, go ahead.
So, Your Honor, the nephew is not entitled to possession of the vehicle, Your Honor, as you know. He's essentially using it. The title holder is Mr. Nowden, and he's not entitled to possession such that Astera would not be able to supersede whatever right he is claiming in the vehicle. So obviously, as we sit here right now.
Let me stop you for just a moment. Because, it started to sound like law school, but here's my point, is that it seems to me that that the defendants in this matter are willing to accede to the demand of their nephew. If he's able to come up with the money to pay off his debt, then that's between them if they want him to keep the vehicle or not. I guess that's
undoubtedly, yeah. Undoubtedly, Your Honor. The issue, though, that I have, Your Honor, and obviously we'll take, if someone's willing to pay it, that's great. But now this is several weeks after the initial hearing. We were not contacted. If he wanted to pay off the vehicle, he knows how to do it. He has not. This is a depreciating asset. So every day that goes by prejudices my client. So we're willing to listen to an offer for the vehicle to pay it off. And we'll take whatever payment that is set forth our way. But we need to know where the vehicle is so we can confirm the whereabouts. We need to know it's insured. There's a lot happening here, Your Honor. So I'm afraid if we push this out for another couple of weeks, nothing will be done in that intervening period of time, and that we're going to be 3 weeks down the road car would be 3 weeks less valuable, so on and so forth. So I understand where you're coming from, Your Honor. At a minimum, can we get an address? Obviously, the family here knows where the vehicle is, where the nephew lives. Can we get an address so that we can, at least I can go back to Astera and say, we know where the car is? Because right now we don't.
Yeah, this is the third time that you made that request, and it's a reasonable request. And I think that I've opened the door for the defendants to provide that information. So any scenario where the court might adjourn this matter does not in any way interfere with the claimant delivery order that allows the vehicle to be seized. So again, the onus of this rests on the shoulders of the defendant in this matter, Mr. Nolan, as to whether or not he could possibly benefit from having the vehicle turned over or whatever he wants. So it would not be a stay on the order. And if Mr. Nolan wants to provide information, he should provide information as to where the vehicle is, because that's in his best interest.
Exactly, Your Honor.
Yeah,
But if he knew where it was, he would turn it in.
Well, I mean, that's what I'm getting at. They called him, but they don't know his phone number. They know he has.
No, because he changed phone numbers. He called from I don't know if they the card phones. I don't know where he called from.
Well,
You know where he lives?
I don't know where he lives. If I know where he lives, you think I would let my brother pay $16,000 for a car? I know where it was.
Exactly. Thank you.
I would get you that in a hurry.
Thank you.
That's what we've been asking for 3 or 4 times today. So if you don't have that, you simply don't have it. The point is that whatever information is not available or being provided here is hurting Mr. Nolan. I mean, that's the bottom line here, is that if he has some way to contact this individual, even if he's talking about paying it off, if he wants to pay it off, some contact is going to have to be made. Otherwise, what you're going to have is you're going to have a $16,000 judgment, and you're going to have an order to seize the vehicle, and all of that's going to be in place. So if there is some indication now that the defendant is going to pay off the vehicle, the 2 things that will be at work is he must make contact with the attorney and have an agreement with Mr. Nolan regarding the payoff of this vehicle, and he has to do that within the next 2 weeks. And then I'm going to set this. For review just beyond 2 weeks, so I can take another look at it. And again, I take the motion under advisement for entry of default and/or for judgment on the pleadings. So the next action date on this is going to be 5/2/2022 at 9:45 a.m. 5/2/2022 at 9:45 a.m. There's nothing about court's determination and adjournment today that in any way stays the execution of the order for seizure of the vehicle.
Thank you, Your Honor.
All right. Besides, well, go ahead, ma'am. I got other cases. You have something else you want to tell me?
I wanted to know who can I get his number, because he gave me a number last time and she pretty much cussed me out.
All right, so you have a number on the pleadings.
Well, I mean, that would not have happened. However, the number you can reach me at is 616-336-64.
Say that again. Say that again. You blanked out.
Okay, sorry. 616
Mm-hmm.
336
336 it is.
64.
336.
Yes. 6491.
91.
Yes, ma'am.
Okay.
All right.
Okay. I give you a call in probably about a week.
Okay, thank you. I'll look forward to that.
Is it possible I can get a statement on how much he owed, the exact
Yes.
amount?
I can, yes.
Okay, thank you.
You're welcome. I will, once you call me, then we'll provide that, okay?
Okay, thank you.
Okay.
I see you on the 2nd of May.
Thank you, Your
Thank you,
Honor.
Judge.
Thank you, Nodens.
Bye. So he's saying 16,000. 16,000. And if he make a judgment.
All right, let's see, counsel on LBNB funding. This Bidix, there was something that you were on. What am I missing, man?
Yes, Your Honor, I had another case that's scheduled for 10. I think it was for 10.
All right, I'll get right back to you in just a moment, okay?
All right, thank
Mr. Fay and Mr. Mance, we're back on the record in 0878.
Yes, Your Honor. We were able to discuss in the breakout room, and we were able to resolve it by way of a consent judgment. I indicated to Mr. Mance that if we could place the terms on the record, and then either if Your Honor wants us to mail him a copy, the consent judgment to sign, we can do that. Otherwise, if the terms are on the record, we can email the court, and Your Honor can sign off on it.
All right, yeah, go ahead and put the proposed terms on the record, and let's make sure everybody's on the same page. Go ahead, Mr. Fay.
Perfect. Mr. Mance indicated that he's willing to sign a consent judgment for the complaint balance, the $1,595.53 plus the court costs, which is $159.40. The total judgment balance would be $1,754.93. Mr. Mance indicated that he will be making monthly payments in the amount of $250. First payment due by May 20th of 2022, and then continue on the 20th of each month thereafter.
All right, and at the end, of course, you receive a satisfaction judgment.
Correct.
Showing it's been resolved, correct, Mr. Fay?
Yes.
Mr. Mance, is that the terms as set forth on this record? Is that in fact what you agreed to, sir?
Yes, they are, Your Honor.
All right, so what's going to happen now is that Mr. Fay is going to send a copy of those terms to me, and I'm going to sign it. And I'm going to go ahead and tell them to put your initials on that document because it's been put on the record.
Okay.
I consent. And when I get the document, I'll make sure that it says exactly what the terms you agreed to, and then I'll sign off on. And then a copy will be mailed to you, and your first payment would be May 20th, 2022. If for some reason, and it's never happened, but if for some reason you get the order and it has something in there that shouldn't be there, something that we didn't agree to, understand that's a mistake. And all you need to do is reach out to Mr. Fay or contact, come back into this Zoom on any day. And,
okay.
Indicate to me that Judge, there is something on there that shouldn't be there, and I'll get a hold of Mr. Fay's office and they'll come in and we'll get it resolved. That never happens. If something go wrong, you're not, this is not designed to be some kind of setup where we got you.
I understand, Your Honor.
I'm not on either side. I'm in the middle trying to get this resolved. So everybody wants us to work out. Sometimes mistakes are made and something happens, and there's a way to correct. Okay.
Okay.
I will consider the case resolved, and Mr. Fay, you can go ahead and send the order in under the terms as set forth on the record.
Perfect. Will do, Your Honor.
Thank you, Your Honor.
Thank you, sir. Good day to you. Glad that things are going better, Mr. Mance.
Thank you. Have a good day.
Have a good day.
Judge, give me time to choose you show your trial. Okay.
All right, this is case number, and Mr. Fay, I've got your matter in just a moment. This is number 02143933. This is Ford Motor Company versus Gene Martin. The matter is before the court. Looks like on a petition for objecting to a writ of garnishment. All right, it looks like in this matter that a judgment was entered in this case on.
Hello?
Well, it's not jumping. Oh, yeah, it was entered on the, well, let's deal with the amount. It was entered for $8,165.20. Looked like that was June of 2003. Looks like subsequent to that time, the judgment was renewed. Counsel, your appearance before motor.
Yes, good morning, Your Honor. This is Natasha Dixon on behalf of Ford Motor Credit Company. My P number is 82333.
All right, thank you, counsel. And now I'm looking for Gene Martin, please. Mr. Martin.
Yes, Gene Martin's here. Yes.
All right, thank you, Mr. Martin. I received your objections to the writ of garnishment in this matter, and I also received a motion to satisfy the judgment in this matter. On your objections to the writ of garnishment, it indicates that the judgment has been paid, and it indicates, secondly, that the writ was not served on you. So when you talk about the judgment's been paid, what do you mean by that, Judge?
Judgment was paid back in 2003. Me died. And, I went to court for it and everything, and I thought it was satisfied. I haven't heard nothing in 20 years, Your Honor. Almost 20 years. I haven't received anything or heard nothing in almost 20 years.
All right. You
This
point out
is
to
the
me
first I'm
that
hearing of it. This is the first I'm hearing of it when they start garnishing my check.
yeah, well, this judgment, the file shows that this judgment's been in place since 2003. Now, you said that you paid it back then?
Yeah, Me Dodge paid. I had got a lease from Me Dodge, and they paid the debt. They paid my lease off at Ford, the Ford Motor Company I had. I had a Ford first, and they paid the lease off. That's the only way I was able to get the car. I mean, I don't see how they coming up with this amount.
All right. So have you paid any money on this since the judgment was in?
No, I haven't. And I haven't received no notices or nothing from it since then.
All right, let me take a look here. Yeah, it's been entered since 2003, and then it was renewed in 2013. Again, it's started out at 6,800. Looks like it at some point it's 8,100. This judgment seems to be ongoing, that you have not there have not been any payments since the judgment was entered, and there's been no motion or anything to set the judgment aside. Let me hear from Madam Counsel on this matter. Ma'am, talk to me. He says he's paid it all.
Yes, Henry. So the current balance, there is a balance on this account as of today. It's $7,305.85. The judgment was entered in 2003 and renewed. We have not received, any voluntary payments. We recently received 2 wage garnishment checks, but we have not received any voluntary payments. So there is a balance on this account. And as far as Mr. Martin's claim that, he was not served at the garnishment. Well, we did serve the wage garnishment upon his employer, LCT Trucking. So they're the ones who served the garnishment to the employees. So, and we did a breakdown. We also showed a breakdown of what, how the balance came to be at that point, and it very much shows a balance. So, Your Honor, we do request that the motion is denied because what he claims does not fall. There's no proof, and it does not fall in within MCR 3.101K2, any of the exemptions.
Yeah, and well, it looks like, Mr. Gene, it looks like back when this case was filed, we filed an answer. The case was mediated. It looks like this case was the subject of a bench trial. And ultimately, motion for summary disposition. So you were aware of this case back in 2003 because you filed an answer to it.
Exactly, that's what I'm saying. I'm here, and then after that, I received nothing in almost 20 years, Your Honor, nothing. I mean, and all of a sudden they find me. They find me now by my Social Security number. I mean, why haven't I received anything in between the time? That's what I don't understand.
Well, all I have to say about that, Mr. Martin, is lucky for you they didn't find you earlier. But it looks like this judgment is validly entered. I don't see where there's been any. I don't see where there's been any paying it off since its entry. There's nothing that shows that.
Wouldn't the statute of limitation be in effect by then, since I ain't received nothing in over 19 years?
No, that's not how the statute of limitations work. The statute of limitations basically addresses before the case is brought to court. With this being a claim of breach of contract, they would have had either 5 or 6 years to bring the claim. So they brought the claim and it's been in court. And then they have 10 years once they get the judgment. And then if it's not paid off, they can petition the court to renew it for another 10 years. And that's what happened. They've got petition to renew it for another 10 years in 2013. And that's the judgment that they're dealing with now. So no, it doesn't go away unless you reach some type of agreement or you pay it off or something. That's the only way that this goes away. All right, so Madam Counsel, you said that you received some payments by garnishment. How much have you received so far from the garnishment?
Yes, Your Honor. So we received two totals. So one of them was it was on April 7, 2022 in the amount of $197.22. The second one was $197.22 for a total of $394.44 received between those two garnishments in April of 2022.
Thank you. So sir, you get paid every week, is it?
Yes.
So you get paid 4 times a month is what I'm saying, correct?
Correct.
All right. So basically, that garnishment is hitting you for $800 a month. That's what you that's your understanding, correct?
Correct. And I'm so stretched thin, Your Honor. I can't that's not helping me at all. I mean,
yeah.
I can't even.
So let's all right. So I don't see a basis for setting the garnishment aside under your petition, and I don't see a basis for satisfying the judgment. There's just nothing there. But let's talk about what can you pay per month, sir. Let's see if we can get you on something voluntary.
And I'm stretched so thin, I'll be about $100 a month. Honestly, I'm so stretched thin, I'm not gonna even lie. I am stretched so thin.
Well, I don't know if you can get from 800 in the garnishment to 100 a month on a judgment that's over 7,000. That's
$150 a month.
Madam Counsel, what are your thoughts on this?
Yes, Your Honor. I mean, like you said, we would prefer more, but I mean, we want to work with Mr. Martin. So if that's the best he can do, that's a reasonable amount for him per month. We can accept the 150. We would prefer more because, like you said, we are receiving more in garnishment. But I suppose if there's ever a time, if his situation changes, he can always call us to increase it, the payment. But 150 is fine for now.
All right. So I'll go ahead and allow you to make the payments voluntarily at $150 per month, and I'll allow that to commence. Commencement date on the 20th of May, 5/20, and I'll stop or suspend the garnishment. So what happens is that the way that this works, you got to make the monthly payment as it becomes due, or the garnishment will be put back in place because it's only suspended. And then the other thing is that because you're paying at the rate that you're paying, interest continues to accrue on this. So you get in a position where you can pay more, you want to do that because otherwise, you'll be spending your wheels a long time because of the interest on the judgment. But I'll allow you under these circumstances to get from under the garnishment on a suspended basis, contingent upon the making of the voluntary payments. All right, so you'll receive an order from me. One is a partial payment order, another is order denying the objections to the writ, but stopping the withholding based upon a partial payment order. You understand, sir?
Yes, I do.
All right, I wish you well, and hopefully you get this all resolved going forward, sir. Good day to you.
Thank you, Your Honor.
Thank you.
Thank you, Counsel.
partial payment? Yeah, it should be. Yeah. I said, they ain't put them up here so you can find them.
Got you. So I'll take care of it.
Yeah.
Thank you very much. This is case number 15-113716. This is BTE Energy Price. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case on the 20th of October 2015. And that judgment was for looks like $2,467.04. The objection that the writ of garnishment as to defendant's employer, indicates, the objections indicate I never received any paperwork, was never notified. The record should reflect that the file indicates that defendant was personally served in August of 2015. All right, your appearance as plaintiff.
It's Craig Fay, P81401 for plaintiff.
All right, thank you, counsel. And I'm looking for Mr. Price now. Good morning, Mr. Price. I think you're on mute, so take yourself off mute, *6. There you go. Hit *6, that should bring you off.
Oh, okay.
All right, good morning, Mr. Price. Say something, Mr. Price. I see you're not, maybe you need to turn your volume up because I see your lips moving, but no sound. Say something, Mr. Price. Rose. All right, I see your lips moving, but I don't hear anything. Do you have your volume up enough, or something that's going on? Now you're on mute again. So, Mr. Price, why don't you hang up and zoom back in? Just start over. Hang up and start over. Just come back in. Dial back in. I'll be waiting for you. All right, we'll come right back to you, counsel, on this matter. Sure. Mr. Price? He's trying to make his way back.
Judge, I think he was on the phone and video. See, there he is.
He's been working all day.
All day.
You want me to just call him? Because he's been on here. You want me to give him a phone number?
Yeah. His sound is not connected to whatever device he's calling.
You gonna put, yeah, 5226. I mean, 9652292.
9652292.
All right, this is case number 04110886. This is Auto Credit Corporation versus Tina James.
Hello?
Yes, Mr. Price.
Yes.
Good morning to you.
Morning.
Case suffix 3716, BT Energy versus Vincent Price. I saw you about to the writ of garnishment in this matter. There is an outstanding judgment, and that's the basis of the garnishment. Think that you should be garnished, sir?
Yeah, no, I shouldn't be garnished. The paper, I never had a DT bill. They say I signed some papers back in 2015 on an address on Hartwell that I never lived. They sent some letters to my job that went to my sister's house. So I don't know how they, you know what I mean? They've been taking my money since last year. I tried to talk to someone about that in the office. They didn't tell me anything about I could have called the court and got all this stuff. And they sent me different letters after that and took my money. You know what I mean? They sent me default letters. Then I got my money. Now they want to send me default letters.
All right, sir. Well, this has been going on since 2015, and the judgment's been entered since that time. If you believe that you have basis to attack the judgment, you have to do that separately from objecting to the garnishment. Two things. One is a post-judgment and pre-judgment. So the underlying case is a pre-judgment case. Once a judgment is in place, then the plaintiff has the right to collect on that judgment. So the matter that's before me right now is post-judgment. If you believe that something went wrong in the underlying case, you have to file some type of motion or document to try and get that set aside. But right now, the only thing that we're dealing with is the fact that there is a judgment and that they're collecting money from you. You said the garnishment has been going on for how long?
Since last year. And they done been paid. They got my they took my income tax. They done took about over $2,000 out of my check while I'm working. So they overpaid what they told me was supposed to be owed to them. But that one was owed to me because I don't. The bill is not my bill. That's fraud. Man told me I signed a paper in 2015. I never signed any paper.
Stop. You already told me that. If you believe that the judgment should not have, you got to file something like a motion to set it aside, a petition to set it aside, and put in that petition the reasons you believe that the judgment should be set aside. Because the only way you get away from the garnishment or some payment is if that judgment is removed. And if it's determined that the judgment should never have been entered, then you would be entitled to a refund of any monies that you paid. So you would have to file something to try and attack the judgment, knowing that it's been in place for more than 7 years now. And the first time that anybody attempted to intercept your income tax or anything, you should have filed something then to at least try to bring it before the court.
I tried. Excuse me, Your Honor. I tried all that. Excuse me, Your Honor. I tried all that. But I had, and then nobody gave me the information. When I first called Steinsberg and told about it, they didn't even want to tell me who was garnishing me. You know what I'm saying? Then when I, looking around and, investigate a little more, and like I say, time to elapse. I got a garnish release thing. So I mean, they didn't get all their money. You know what I'm saying? They garnished my.
Okay, I'm going to the other side now. Mr. Fay, has the judgment been satisfied now?
It has. It looks like once we received the tax garnishment that satisfied the account, we did receive 2 payments after that from Mr. Price's employer. We did return them. It looks like on April 8th, they were sent back, and as well as it looks like yesterday. So those 2 checks will be going back to his place of employment. And I believe also, it looks like the account is under review for a refund because of the tax garnishment, which we did receive. I think it was just over $2,001. That would have overpaid the judgment based on the prior collections of garnishments from his PO8. So it looks like he will be getting at least a refund based on some of the the state tax garnishment going back to Mr. Price. And we did, as he indicated, filed a release of garnishment. And I believe that was sent out. I believe the court received it, but it was mailed out. Looks like March 31st.
All right. So a couple of things, Mr. Price. You're correct. The garnishment has now been released. So the question that's before me is a moot question. That there's a release of that garnishment because your judgment is paid in full. Now, 2 other things. Number one is that 2 payments that were taken from you from your employer are being sent back to you because you were overpaid on the collections from your wages. So 2 of those checks are being returned to your employer. You'll get that money back. In addition to that, the money that was collected from your state return was an overpayment. So you'll be getting some money back from that. So you are overpaid. and they are going to return some money to you. If you still believe that you should have never had to pay anything, then you have to file paperwork with the court demonstrating why you believe the judgment should be set aside. And if there's a basis for that, then the money that you paid will be refunded to you. Right now, this case will basically be deemed to be closed because you've already paid everything that you're supposed to pay, and you have refunds coming to you.
Well, what papers should I file as far as I'm saying it's been a fraud against me? They took my money, and I want to get my money back.
As I mentioned to you, you have to attack the judgment. If you believe that the judgment was not properly entered, you would file some type of motion with the court. On the second floor, you file a motion to set it aside and put forth the reasons why you believe that the payments are straight, that the judgment should not have been entered. That's how you would go about that. You would also have to explain. You would have to explain why you didn't take action over the last 7 years. You have to show good cause as to why you didn't take action in the last 7 years. And then you have to show that you had a defense to this. And your defense, as you indicate, was fraud, that it was not your bill, so on and so forth. And you file that and the court will take a look at it. All right, so I'm signing the appropriate orders now. The garnishment is in fact, the objections are deemed to be valid. And that means that the garnishment is stopped. And it means that any funds withheld will be released to the defendant. So ordered.
So they're saying that the money they took for my last two checks will be sent to me when?
Well,
it's been over.
No, don't ask questions, keep talking. It seems like they've already sent it, but it hasn't arrived back to your employer yet. So there are two checks. The last two times you got garnished, both of those checks, both of those are coming back to you. Okay?
It go to my employer.
Yes. And your
what about my income tax check?
And that will come to you. That will come to you once they work that out. The portion that was overpayment will be sent to you. All right, sir?
Okay.
Okay, to you, I wish you well. All the best, sir.
Thank you, Your Honor.
Thank you. I'll call Steinberg. I'll call y'all back on whatever the issue is on this here. They will solve this.
You know I'm finished with your case and you still talking, all right? Goodbye, Mr. Price.
Have a good day, Your Honor.
Thank you. All right, let's see. Yeah, I'm on the record regarding Automotive Credit Corporation versus Tina James Bay regarding objections to a writ of garnishment at PCN Bank. This is the suffix is 04110886. Your appearance for automotive.
Good morning, Your Honor, and Object Francis on behalf of Plaintiff's Attorney of Record, P72322.
Thank you, counsel. And I'm looking for Tina Latham, please.
Yes, here.
Where are you, ma'am? Say something again.
I'm here, Judge.
All right. Good morning to you, ma'am.
Good morning to you also.
I see that you filed. I see that you filed a objection to the writ of garnishment. Your name is in the case. It was Tina Latham. It's Tina James Bay now. Is that correct, ma'am?
Yes, for 20 years.
Wow. I knew that off the top of my head. The file has you as Tina Latham back in 2004, and I was just updating you. It is which one is correct now? That's Tina James Bay, correct?
Yes.
Okay. All right. So your objections to the writ of garnishment, you say that the writ was not properly issued. And
yes, I don't.
So tell me what you mean by that, ma'am.
I don't know anything. I don't know anything about this. I don't know where this coming from, and I'm on disability. I haven't filed taxes in 5-6 years, and when I was working, I don't understand. I don't understand what this is.
So So here's what happened back in 2004. There was a summons and complaint that was served personally. That's what the file shows. That subsequent to that time, in May of 2004, the judge entered a judgment against you by default, where you didn't answer the complaint. And that default judgment was for $10,047.28. And since that time, the plaintiff has attempted to collect several different ways and have not been able to do so. And then recently they were successful.
On the account that I'm not the primary I'm not the primary person on it. It's my daughter's account. Yes. And she's in college.
Okay, yeah, your name is.
Yes. She added my name to it. Yes.
Yeah, but that makes you an owner of the account. That's why they would be attacking that. All right. Well, let's figure out what's going on here. How much money is in that account, you know?
None. She's a student. She's in college.
Okay, but there's no money there?
No, that's about $3 and I don't know what she does. I'm on the account for emergency reasons because she's in college. I'm in Detroit, Michigan. She's in Grand Rapids.
You're telling me that 6 times about it's her account and you're on the account. You don't have to tell me that no more. I heard you the first time. We're moving on to something else, okay? And I'm glad that she's away in college. She's there in Grand Rapids with Ferris State.
Yes, she is. She's graduating April 30th. She's criminal law. Yes.
That's excellent. Excellent that she's making her way forward. Congratulations to both of you. Let me find out.
Thank you so much.
Let me find out from Ms. Madam Counsel, what's going on this?
Judge, we did get a disclosure that states $60.53 were being withheld from the account by PNC Bank.
All right. So she says that the funds there are totally held by her daughter and that she's just on the account.
They did put on the disclosure that both of their names are on it, so they found that they can withhold the funds. And so, Your Honor, since defendant is a joint owner, we would ask that her objections be denied, as she would have the full ability to go in there and withdraw the funds herself as well.
Yeah, so, ma'am, now, so what happens with this? Do you withdraw the funds? Do you take money out or put money in? Do you deposit money for her or anything like that?
Yes. Yes.
And that's the thing that makes it a jointly owned account. So it's only $60 there, but it looks like they
right.
They caught you on this one, so I think they're entitled to take the $60. And of course, you don't want to put any more money in that account or have her put any more in there because they have a garnishment on that account.
Okay, yes, I'm going to close that account. She's going to have to close that account because this garnishment is, I want to know about the garnishment. That's the simple part. What is this?
Well, I don't have any basis to go beyond that, but simply to tell you that a judgment was entered against you way back in 2004. And that's why this is coming up. So and I told you the amount of that judgment. As long as that judgment is in place, the plaintiff has the right to try and collect on that judgment. You could certainly file a petition to make partial payments if you believe that that's the way that you should go with this. But otherwise, it will be something that's hanging out there that the plaintiff will be entitled to collect wherever they may find some money, in a bank account or anything.
Okay.
Right. So that's going to be. I will release the funds withheld to the plaintiff. On the
why would you release it to them? I haven't made no payments to them. I don't even know what this is. I haven't paid nobody. I don't even know what this is. What the world is it? It's in Tina Latham. I don't understand this.
Well, you may need to. All right, you made this is a judgment against you. The main part for you to understand is that it is a judgment against you for over $10,000. And as long as that judgment stands out there, the plaintiff can use any collection methods that are allowed by law to collect money anywhere that it may come up.
Without me knowing anything about it. So people can just do whatever they want without you knowing anything about it.
If that's what you
I
like
mean,
if that's what you like to conclude from this discussion, then you can conclude that, but you know that's not what I told you. I told you that there is a judgment against you. That's where everything starts at. Now, if you believe that that judgment should not be against you, you need to file something, file a motion. ask the
Okay.
court to you do something on the judgment. But no, nobody can't just come and collect money from you. But if you have a judgment,
Okay.
if I have a judgment against me, person holding that
Okay.
judgment collecting my money, they could intercept my account, intercept my state income tax return, all of that. Okay, so that the reason that
Okay.
you get is because there was a judgment entered against you in 2014, sorry, that in 2004, and that judgment was for $10,000, and that judgment is still in place. That's the problem. Okay.
Okay.
All right.
And
so,
okay. I don't know
so-
how it's in place. I don't, that's why I don't understand. Okay.
Exactly. You have to search that out and perhaps file a motion with the court regarding the judgment that was entered against you. It does look like that judgment was entered based upon I think it was some type of account or something. I don't have the file in front of me, but you could always get access to that account at 36 District Court. All right. I wish you well, ma'am. Good day to you.
Okay, wait a minute. I'm on SSD. I receive $899 a month. What do I do about this?
Well, you're trying to get me to be your lawyer, and I can't. First of all, I will tell you that anything that you're collecting, like SSD and so on and so forth, they can't garnish that. That's the reason why nobody has come after your payments and Social Security or anything like that, because that's not collectible. None of that is collectible.
Okay.
But if you got
Okay,
money-
Judge, again, could you tell me how, you said, do I have to file something?
I already went through all of that with you, ma'am. I got a bunch of people waiting for a hearing. That's the only reason I'm rushing you now. The reason I talked about 5 times is because I wanted you to have some information. I can't tell you all of it, but you got some information. Now I have to go on to other cases. Other people are waiting. So all the best to you, man. They can't collect your disability pay. There's nothing they can do with it. All right. I wish you well now. This is case number 0615095. This is Asset Acceptance LLC versus, looks like, last name is Turner, but it looked like Jaquel Turner. The matter is before the court on the filing of objections to a writ of garnishment. This is regarding third-party state of Michigan income tax return, it looks like. Asset acceptance, counsel, please. Counsel for asset acceptance. Do I have Jaquel Turner on the Zoom? Say something if you would.
Yes, Your Honor, I'm here.
Thank you, Ms. Turner. Ms. Turner, you filed with the court your objections to a writ of garnishment indicating that this is past the statute of limitations and does not relate to you. The statute of limitations issue, ma'am, there was a judgment entered in this case. That judgment was entered on the 6th, it was renewed on the 16th of November 2016 for $3,198. There is no statute of limitations problem here. This judgment can remain in place by renewal as long as there is a renewal application filed. The judgment was initially entered, it looks like, back in 2007 for $3,198.27, and then, as I mentioned to you, in 2016 it was renewed. So there are no statute of limitation problems regarding this. And so the judgment remains outstanding. If you believe that there was some reason why this judgment should not have been entered against you, you do have the right to file motions in that regard, asking the court to review the matter as to whether or not the judgment should have been entered against you. It looks like this was a claim for a debt that you had with asset acceptance or some other entity that ultimately was brought to court again back in 2000. 2006, and then the judgment was entered in 2007. All right, so
Okay.
how much money is with the third party? How much money are you expecting from the Department of Treasury?
They took my state taxes $1,005, but I'm really calling to see who is garnishing me, because when I called them, they gave me two different addresses. I don't know if this still stemming from the DTE bill. I don't know why I'm being garnished. That's why I sent a copy of my my deed, because when I called, they gave me my mother's address, which I never had a DTE bill over there. And then they told me my address, which the default that they was trying to give me, I wasn't even in this home at that time. So I'm just trying to see where's this bill coming from and what is the, the address on file. I don't have any of that information.
All right. So, quite honestly, the court has a jacket and does not have a complete file because this is a case from 2006. So the file is likely in some type of storage because of how long it's been around. But if you believe, or if you find out that there is some basis to try and get the judgment set aside, that this was not your debt, then as soon as you have information to do that, you will want to file something with the court on the second floor to try and make that happen. Because obviously, if you can prove that this judgment should not be your judgment, then you will be entitled to have money refunded to you that you take. Like right now, again, you have a judgment that's been around for more than 10 years. And it looks like there have been, previously there was a garnishment and you filed an objection back in 2020. So you've known about this for a while. You would have to, it looked like you filed a motion to set aside a default back in 2020. So you kind of.
Yes, I did.
Yeah, you kind of already raised those issues. So, I mean, you've taken the steps that you can take. The judge that ruled on those issues determined that there was no valid basis for setting it aside. So that's where the case is. Since it's not past the statute of limitations based upon the file, I don't see a basis to set the garnishment aside. So that means that the objections are invalid, and the funds that they took from you will be released to the plaintiff towards satisfaction of the judgment. So I do wish you well, ma'am. I wish there was something else that could be done here, but that's the size of it. That's the only thing I can see that can be done to deal with this case at this time.
Okay, and how long do I have with them to do the motion, to file the motion?
Well, you can file a motion at any time, just as you've done in the past. Nothing prevents you from filing a motion if you wish to do so.
Okay, now one more question, Your Honor. I don't have that paperwork. Okay, now by them not appearing on the line, they still entitled to the garnishment?
Oh, absolutely. You are the one that had to be here. It would be good if they were here, but you had to be here because it was your motion that you filed. Yeah,
oh, okay, no, because what?
And then the next thing we do is we look at the file to see whether or not the file backs up an outstanding judgment. Because it does, that's why the court has made the determination that it's made.
Okay, I understand. So I go back to the second floor, correct?
Yeah, the second floor is where you could get any information on this file and where you can file any paperwork.
Okay.
Okay, I wish you well. Now, I hate those old judgments, but they live on and on and on. Sometimes they renew the third time, and the collection goes on for 30 years. So if you could find a way, you've already paid a substantial amount on it just recently with that garnishment. And you might want to look at a way to do partial payments if nothing else to try and get satisfied. All right, I wish you well, ma'am. I'm moving on to another case as I have to.
Thank you so much, Judge.
Absolutely.
Bye-bye.
This is case number 1011-0326. This is Calvary Portfolio Services LLC versus Carswell. A matter before the court on objections to the filing of a writ of garnishment. This appears to be a writ of garnishment filed with the Michigan Department of Treasury. This also appears to be a judgment rising out of a default judgment that was entered initially on the 15th of September 2010. Looks like it was renewed on July 23rd of 2020 for $22,199.48. All right, your appearance for Calvary Portfolio, please.
Good morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
All right, thank you, Counsel. Good morning to you. I'm looking now for Ronald Carswell. Good morning to you. If you're there, sir, say something. Mr. Carswell. Ronald Carswell, please say something if you're there. Mr. Carswell, living on Gainsborough Street. If you're there, please say something at this time. Looks like the defendant has not appeared on the objections. The objections noted the funds are property are exempt from garnishment by law. There was no explanation of that presented, but the defendant indicates the funds are exempt. Counsel, anything you have to say at this time?
This is an invalid objection, which the grant took or deny the objection to garnishment.
All right. You don't know anything about any exemption on these funds, do you?
No, I do not, Your Honor.
Given that defendant has not appeared and did not express on his petition as to what the exemption of any funds might be in this regard, the court will now find that the objections are invalid, that the funds will be released to the plaintiff regarding this matter, with the objections being denied at this time. Is so ordered. Okay, thank you, Counsel. Good day to you, sir.
Thank you, Your Honor.
The court now calls case number 14120-380. This is Universal Collections LLC versus, it looks like Charles Simpson. The matter is before the court on the objections to a writ of garnishment. The objections arise out of an effort to collect from diversifying credit unions. That a judgment was entered in this case on the 15th, check that, the 5th of June 2015. That judgment was 3,000, strike that, $1,364.11. For appearance for the plaintiff in this matter, Counsel.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322. Your Honor, there is someone on a phone and there was a lot of feedback and could not hear what you were saying.
Got you. I am on Universal Collections versus Charles Simpson. Do I have Charles Simpson?
Yeah.
Mr. Simpson, good morning to you. Say something again because you didn't light up.
Oh, yes, I'm here.
Okay, I got you. All right, thank you, Mr. Simpson. You filed objections to the writ of garnishment based on a judgment that was previously entered in this matter for actually $1,346.96. Your objection says you moved out of the apartment in good standing and into another property. That would not be an objection to this matter, sir. This judgment against you. You would have to, sounds like you want to attack the underlying case, and you would have had to file something in that case to attack the judgment. Right now, there's already a judgment entered, so the only issue is whether or not they have the right to collect the money. And those boxes that are existing there, what would stop them from being able to collect is if the funds are exempt or in bankruptcy, or you're paying on an installment plan or something like that. Do you have any other reason why you believe that you should not, why you should not be able to garnish your wages at this time or garnish your account?
I mean, that was an old case. Like, I moved out of an apartment and moved to another one of their apartments. So I don't understand how I can owe them. They never sent me a bill for it. It wasn't on my credit report. I don't understand. They sent to an old address. I've been a homeowner since 2015. I don't know how they get my new address. So they did no type of due diligence to actually find me to get to the bottom of this case.
All right. Well, the court back in 2015, the judge that was ruling then determined that that they had exercised due diligence and allowed them a motion for substituted service. They were able to send it simply by certified mail, and then the judgment was entered by default, and there was no response to the certified mail. That's how the judgment got in place in this matter. Right. So now, so let me ask you, how much money is in the diversified account, sir?
Nothing. I'm out of town working right now. I'm in Tennessee.
All right. So there was no money there for them to collect?
No.
All right, Madam Counselor, did you get a disclosure? You're on mute, Ms. Francis.
Sorry, Judge. The disclosure states we got $1.66.
Yeah, well, this is kind of like a moot question then. So, yeah, sir, you can always file something to try and get the judgment set aside if you believe you should do that. But there's no money there, so it's really a moot question. I will find the objections invalid and release the dollar or so to the plaintiff on this account, and that will be the end of this. All right, I wish you well. If you have other reasons, you can file a different type of motion to address those reasons. Sir. Good day to you.
Okay.
Thank you, Your Honor.
All right, thank you, Your Honor.
Thank you. All right, the court is calling case number 19, 165491. This is One Detroit Credit Union versus Jerome Gardner. The matter is before the court on the filing of looks like objections to a writ of garnishment. The record should reflect that the writ of garnishment occurred by virtue of a judgment that was entered in this case. Just one moment. That judgment was entered on by consent on the 29th of August of 2019. The total amount of judgment on entry was $1,667.05. All right. Your appearance, counsel.
Michael T. Mayor, P. 1102 on behalf of plaintiff.
All right. Thank you, counsel. Do I have Mr. Gardner or Grenier on this Zoom?
That's Gaynor, Your Honor.
Thank you, Mr. Gaynor, and good day to you, sir.
Thank you.
You signed, you entered a consent judgment, and now it wasn't paid, and they're seeking to collect through intercepting the credit union. Talk to me, sir.
Well, yeah, I before that the pandemic, we had made a payment arrangement and everything, and then during the time of the pandemic, I kind of fell off, and lost my part-time job, and I was working on and off, and a lot of other expensive things took place during that period from 20 to 2022, where I'm at now. But I'm not in disagreement with what I owe or anything like that. But right now, I'm not working because of medical issues, and I would like just set up a payment arrangement, because right now, I don't have those type of funds in my account for that to happen, because I still have family responsibility and obligation to handle right now. So, I'm not disputing that at all.
So how much money is in the account?
Probably maybe $113.
It's almost a good question. I mean, you owe some money there. They'll likely they'll be able to take that $113, but then you can set up a payment plan after that. But the only question here today is whether they can take that $113.
I mean, right now, Your Honor, I'm not working because of medical issues. I won't be able to go back to maybe the 5th of May. And, they know what account's at. I mean, I have no problem of them, withdrawing $50 a month or so, because it's not like it's $1 million. I understand the amount, but, it's just that things did occur during the pandemic. We had arranged, I wasn't working on and off like everyone else, went through a lot of things, but, it's not like, I should feel like I should, do something crazy over the amount that's owed. And if it can come out, we can get it on payment range, that's fine, because I know I'm going back to work, next month. And I'm just been, just the last couple of months, just been off work because of surgery. But other than that, it's been difficult times, just like everyone else, but I'm not, running from that obligation. I understand the payment, we spoke about it prior before, but pandemic struck and turned things around for a lot of individuals. So, here we are.
Counsel, did you get a disclosure from public service?
I did, Your Honor. And if I might shed some light on the procedural history, last month we had a hearing on an objection to garnishment and a motion for an installment payment plan. The defendant failed to appear. Both of those motions or the motion and the objection were both denied because he failed to appear. After that, those funds were released to our office. It was $623 and some odd cents. And once those were actually, what was that?
That was involving this particular case?
I believe so, Your Honor.
Okay, go ahead, sir.
Oh, and once those funds were released, this account was actually paid off. So I have a release and a satisfaction of judgment sitting pending the outcome of this hearing. That being said, as tragic as financial hardship and as hard as these last couple of years have been on everybody, the defendant's objections are not valid.
But the garnishment should be stopped, right?
Yes, I mean, those funds have already, the bank garnishment funds have already been released and the balance is paid.
All right.
If I'm,
Is there any money being refunded to the defendant, or is he overpaid, or he just paid off?
not at the moment, my computer shows a zero balance.
All right.
Okay, so when did this take place? When did they take the funds?
I have my disclosure. The garnishment was issued February 15th. It was received by Public Service Credit Union on February 9th or March 9th, 2022. $623.56 was held. And let's see if there's a set number. Oh, sorry, what was that, Your Honor?
I was just saying, you're all, one way or the other, Mr. Gainer, you're all paid off.
Well, the thing about it, I mean, they did everything so quickly on taking those funds where, and I didn't have any, I guess he was saying that I filed a motion twice. Is that what he was saying?
Yeah.
In March, we had an objection to a garnishment and a motion for installment payments, I believe.
Okay, so from that period of time, then I have, I was supposed to have what, 14 days or X amount of days to file a motion?
I have no idea. I do see the.
Okay, after I received the first letter, I believe after I got out of the hospital with surgery, I received the letter. And that was stating, I think around that time, the 9th or something like that. When I read the letter, it said, okay, I had X amount of time to file a motion, which I filed a motion, but obvious they had went and took the cash anyway. It seemed like, I didn't have enough time to get the motion in, and which I'm thinking I had what, 14 days or X amount of days to do that, correct?
I got it. I received the motion. I just looked at the file. I received your motion. On the hearing date, you were not here. And of course, because you were not here, then the motion was denied because you were not present at the hearing. That's what happened in the March hearing.
And that day, excuse me, Your Honor, what day was that March one? Which day was that in March?
That was March, just one second.
It was filed, I believe the hearing was April 6th, if I'm not mistaken.
Oh, yeah, you're right. Yeah, I saw the filing. The hearing was April the 6th. Exactly right. And the court, the objections were denied and the motion for installment payments were denied because the main reason was because you weren't here. that hearing was set for the 6th of April.
Okay, so that was the hearing for the 6th of April. So yeah, I remember that day because I was I had to go to emergency that day. So on that day, April the 6th,
Yeah.
and you mean to tell me that since I didn't show up for that day, they can immediately just go ahead and take the funds, or it was already taken? You know, I'm kind of like confused about this 14-day window, or the window I'm supposed to have to file the motion. It just seemed like they were real aggressive about handling their end, and I didn't really get an opportunity to really fight on my end.
Well, you had opportunity, but you had a misfortune as well. You can't really, you want to attack the rules, and you want to attack the rules and you don't really know the rules. I get that, okay? You had a misfortune. You filed the stuff in proper time, and you got a notice of the hearing date, and you were not here for the hearing date. If someone had informed us that you were having an emergency or whatever, then that hearing would have been adjourned. But when I called the case on the 6th of April, you were not here. Nobody was here to say anything. You didn't zoom in the next day or anything to say that, Judge, I had to go to emergency or something. That's why that happened, because you were not here. You didn't show up. And so you may not understand all of the rules, but you understood the rules well enough to file your motion on time. Filed your motion on time, and I gave you a court date. Once I gave you a court date, that court date was your opportunity to potentially stop what was occurring.
And I understand that, Your Honor. I understand
And when you didn't make that court date, then the failure to make that court date means that the objections were denied at that time. Now, the good thing about it, I don't know what you're asking for here today as I move up to another case. You're paid off now.
Yeah, but the thing about it is that, okay, I understand, you know, I had to go to emergency on April 6th, but that next day, you know, after I, you know, had gotten out of the hospital, I went, called the court and asked them about, hey, you know, this is what happened, and could I, you know, file another motion? And which I did the next following day. And all of a sudden now you know, it's just that I understand clearly how it works and everything, but there was no opportunity. I felt after, you know, everybody going through the pandemic, things have changed, you lost a job and medical things that happened, but it's no grace period on especially on that type of amount of money. You know, it's not like I come from a silver spoons family, anything like that, or have all this going on, but I try to do the best I can. But when you have these type of attacks coming at you, and everybody's in a situation, but I look at that situation for that amount of money to be that aggressive towards me in my situation, knowing what time it is, that's a little bit too over the top for me, Jan. That's all I wanted to say. I understand how it is now. Maybe I was a day late, maybe I got sick, or maybe I died and came back to life. But it's just the fact that I see how everything went down. And I, you know, it's just kind of like on my end a little sour because I did call the court and explaining them what happened. Next day, I was right on. It wasn't like I was lackadaisical or took 4 or 5 days the next day, but it was just my medical issue took place on the 6th, and all of a sudden, my money's gone the next day. That's fine. That's okay, Your Honor.
Well, that is the way that this works, but I do see.
I see how it works now. I see how it works.
I see you're filing on the 7th, and
correct.
You usually don't get a court date this soon. So my clerk accelerated the court date in light of the fact that there were some issues that had occurred. So we got it back as quickly as we can. Yeah, I don't know what issue you want to get at here because.
Well, my issue was that for that amount of money, I could have been on a payment plan. I mean, you know, it just goes to show to me, and it's not, you know, I don't have anything against the court system, anything like that, but it just goes to show that how aggressive some things are when they know some folks are in that situation where, you know, I can just afford to give up X amount of dollars because now you found out where I work or where I'm banking at and all this stuff for that type of money. I just felt a little bit uneasy about that low amount being aggressive for that amount. I can see if it was $6,000, like other prior cases were $6,000, $7,000, but for $600 something, come on. I mean, I you know, I have kids, I got family members, you know, I could have went to food on the table. Everybody's experienced these high inflation rates is going on nowadays, gas and food. And for that, a law firm, a law firm is probably making millions of dollars or more than I'm making and you're making together. And you come after me for 600 something like, wow, it's just.
Well, yeah, I certainly get your point. I will say that in some instances, of course, 600 times, 600 or 1,500 client people that owe it can add up to a certain amount of money. And then the second thing, and more importantly, that I have to say here, there are not a lot of, I don't agree with everything in the way that they take place. But one thing that I have to stand by is the rules. And what you see happening here is you see what the rules of the state of Michigan allow. If you have a judgment against me or someone else, you don't have to be a company or a big office or anything, but if you have a judgment against someone and you seek to enforce that judgment, and you would do the same thing. You file a writ against their bank account or whatever, and you come before. If they don't show up, you get that money right away because they weren't there for the hearing. And even if they call the next day, by then you're going to likely have the money. They may get another hearing, but you'll have the money, and then that hearing will determine whether or not you can keep the money. But it moves fast. It really does, because the laws in Michigan, as well as in many other states, allow for that type of advancement of a claim once there's a judgment in place. Once there's a judgment in place and they find out where some money is, it can be collected, and it can be collected quickly.
Which I understand, I see that, but it's just for the fact that, like I say, the pandemic and other things that took place and inflation is the way it is right now. To just, I can understand if I've made, 100,000 or more a year, or I'm sitting in my account shows, 20 or 30,000 or 100,000, 100 million, like the law firm. I can see that, but for that right there, okay, that's just taking food out my table.
I go on to another case. I'll say simply.
I understand. No problem.
I'll say simply one thing. A lot of agencies were stopped by law from taking any action against people that they had a judgment against for a significant period of time during the pandemic. So if they had a judgment against you, they couldn't come after your bank account or anything because the cases were frozen during that time.
Well, doing that.
No, listen up for just a moment. So during that time, they couldn't collect, they couldn't enforce their judgments and so on and so forth. So that may be some of the reason why, once that was lifted, that they're more apt to move quickly to try and collect, because for a year or whatever it was, they weren't able to collect any money. And I'm not saying I'm on one side or the other of that. I'm just saying that is a factual issue. All right, I got to get on to another case. I wish you was, but it's been a delight talking to you. I'm glad you didn't come up as one of my first cases, because you would have took all the time and you have people mad at me. But I wish you well. I feel your pain. I feel where you are, because you're right. It's been a once in a lifetime pandemic, and it has affected people, loved ones dying, people being sick, all kinds of stuff. And most people have been affected by it one way or the other, financially and otherwise. I have young children, and my son's spent a whole year at home doing school on my computer. And for the 11-year-old, now 11-year-old, he adapted real well. But my now 8-year-old, that was like that was the best thing that could have happened to him, and the worst thing that could have happened for us.
Right.
So it's a big adjustment. So everybody's been affected one way or the other by it, and this is one of the effects. And that's why I took a little bit more time to listen, because I know it's real pain and real issues that are out there.
Yeah. Okay.
All right.
Well, I appreciate that for you, tuning in and everything, and just wanted to express that. But I just thought it was just, for that amount of money, wow, it's just unbelievable.
Your Honor, just for clarity, will the court be denying the defendant's objection?
Yeah, and I've the funds to the plaintiff. That's my order. You receive a copy of it. I already signed.
All right, thank you, Your Honor.
So
I
you have that. So they do have the money.
Yes, sir. And you should be receiving a satisfaction saying that everything is paid off and no further collections.
Okay, Your Honor, you have a great day.
Likewise.
Thank you, sir. Have a good day.
Good day to you. This is case number 16-104-976. This is Midland Funding LLC versus Pamela, looks like Ashman. Yes, The matter is before the court on the following objections to a writ of garnishment. The record should reflect that in this case, a judgment was entered against the defendant. That judgment was entered on the 6th, strike that the 12th of August 2016 for the total amount of $836.77. The plaintiff seeks to collect. And the objection says the defendant cannot afford payment. Do I have someone from Midland on this Zoom? Do I have Pamela Ashman on this Zoom? Any person on the Midland versus Ashman case on the Zoom, please say something at this time. If you are on the Zoom and you're on mute, you would need to push *6, and that will get you off of mute. I'm looking for either Midland Funding or Miss Pamela Ashman on Westbrook Street in the city of Detroit. All right. It appears then that no one has responded to this matter. I looked at the objections which say that I cannot afford the payments. That is not a valid objection under the laws as it relates to garnishment. Therefore, the court would have to deny that objection as being invalid.
She said, I'm sorry, Judge, I which one, Mr. Savage Pamela?
Yeah.
She said that she called and she said she wasn't gonna be able to make it. She wanted to cancel the garnishment, so. Yeah, she called.
All right, thank you, Madam Clerk. The objection on the garnishment would be invalid because it just says I cannot afford the payment. That's not a basis recognized in law. So that for that reason, the objections to the writ of garnishment will be denied at this point. Just a one.
Supposed to get one of them solve it.
That's just. I want to make sure there's one I sent out to check.
So you need to check the second box?
Yeah, I just need to make sure I check.